Good morning. Welcome to our webcast today, brought to you by the Pro Bono Partnership of Atlanta. My name is Surisha Gunta. I'm an attorney with the partnership. And with me today, I have Amy Jensen from Ogletree, Deakins, and she'll be speaking to us today about, are your interns also employees? How learning opportunities may lead to liability. First, I'd like to give you a little bit of information about Pro Bono Partnership of Atlanta. Our mission is to maximize the impact of pro bono engagement by connecting a network of attorneys with nonprofits in need of free business legal services. A little bit of information about our clients. They're 501c3s that are located in or serve the Metro Atlanta area, and they serve low-income or underserved populations, and they otherwise are not able to afford legal services. If you're interested in getting more information about the partnership or in applying for our legal services, please visit our website. Also on our website, you'll find more information about our workshops and our webcasts from the past and future events as well. Please keep in mind that today's webcast is not legal advice. It's just general guidance for you. And today's webcast is also copyright Pro Bono Partnership of Atlanta. And now, Amy, thank you.
Thank you. Good morning. So I'm going to speak today on internship programs and how you can devise yours to comply with the Fair Labor Standards Act, which is the federal law that is applicable to internship program and to wage and hour issues in Georgia. In Georgia, there's not a state law that really addresses these issues, so here we're going to be talking about what federal law applies. So I spoke on this issue 3.5 years ago for a webinar for Pro Bono Partnership, and in the meantime, the law has evolved and changed. Some courts have come out with some new tests, a new test, and just recently in January, the Department of Labor adopted this new 7-factor test, which is a good bit of a change from the 6-factor test that I spoke about 3.5 years ago. That was the predominant test at that time. So we'll get into the details of that test, but first some kind of basics under the FLSA. So nonprofits are not exempt from the FLSA. There's no explicit exemption in the law for your organizations. You may be exempt if the nonprofit does not perform any business activities, but you still could have an employee who would be covered under the FLSA because that employee does work that affects interstate commerce. And that could be as minor as making out-of-state phone calls as part of his or her job. So it's important to kind of keep this law in mind when you're looking at your relationship with your employees. So when it comes to internships, just calling something an internship is not going to get very far. So it's important to look at what the internship really is and whether it does comply with the applicable law, rather than just saying, you know, it's our internship, we've called it that. The label is going to carry very little weight with the court. So let's get into some of the more specifics. So to be covered by the FLSA, you have to be an employee, and interns, if they're true interns, are not employees. But someone working for an employer, so employ is to suffer or permit to work, which is extremely broad. So if you have someone that you suffer or permit to work and they are not otherwise an intern, a volunteer, or some other exemption, then you need to treat them as an employee, and that would mean compensating them with minimum wage and overtime compensation. So like I said, the previous test that had been in use for some time, it was a 6-factor test, and it was based on the law that had developed under the FLSA regarding trainees. So the Second Circuit was kind of the first to reject using this test for interns. It said, you know, the 68-year-old case about trainees for a railroad, it did not reflect the modern internship program, which is a requirement for many academic programs. So they made a big point of recognizing that internships are now almost required for students who want to get a job after they go to either college or vocational school. So the 11th Circuit, which is the circuit that covers Georgia, it adopted this test a few years ago in a case brought by nurses who were required by law to complete an internship to receive their certification. And like I said, more recently, the Department of Labor adopted this test, so now I expect that it would be used by courts nationwide. So the test consists of 7 factors, and we're not going to stay on this slide because it's way too small for you all to read, but these are the 7 factors, and we'll spend our time going through them one by one, starting on the next slide. So for factor number 1, it's the extent to which the intern and the employer clearly understand that there's no expectation of compensation. You don't want to be paying your interns just a little bit because that's just going to lead to the question, well, if you thought they were worth some amount of money, why didn't you think that they were worth paying minimum wage? So it's important to set clear expectations with the intern up front, and one way you can do that is by having an intern agreement that both you and the intern sign. Now, if you're not paying your interns, it's important that they are getting non-academic benefits. Those can include class credit, work that they can put in a portfolio and show to an employer, intensive training, evaluation, the things that will help them start their career or advance their career. Sometimes there would be you would want to do expense reimbursements, and that may be okay. You just want to tread cautiously there and make sure that you're not giving people reimbursement for things that they would have otherwise incurred. So they really would have to be closely related to the internship. So factor 2 is related to the extent to which the internship provides training that would be similar to that which would be given in an educational environment, including the clinical and other hands-on training provided by educational institutions. Now, courts recently have rejected claims from interns that the internship kind of needs to look like school. They say, no, it's broader than that. It's really what are the skills that are needed to help students transition from school setting, from the educational setting to the real world, the professional environment. So giving students or interns the opportunities for tasks that are allowing them to sort of hone their professional skills. So that may involve them having some of the same tasks as tasks that employees perform, but you would expect that the interns would get significantly more training and more time to complete those tasks, even if they end up with the same results. So the third factor is the extent to which the internship is tied to the intern's formal education program by integrated coursework or the receipt of academic credit. So when you're looking at your interns, it's important to consider, what they're looking to get out of it and how it compares, how it relates to their educational experience. What their major is, what their coursework is it a requirement of their program that they complete an internship? All of those are going to be helpful factors in showing that the internship is integrated with the educational experience. And giving them regular feedback. A lot of internship programs have formal evaluation programs where the employer would report back to the school about how the intern is doing and providing evaluations, and all of those are helpful to show that it's tied to the formal education program and it's kind of part and parcel with what they're receiving at their academic experience. So the fourth factor is the extent to which the internship accommodates the intern's academic commitments by corresponding to the academic calendar. So obviously this would, part of this would be looking at when are interns providing services to you. Is it during the summer when they're off of school, or is it a semester-long program that stops and starts with the school calendar? All of those are going to be helpful to show that it corresponds with the academic program and it's part of the academic experience. With a student, you kind of need to have some flexibility with the schedule. Obviously, you wouldn't want an internship to interfere with them taking classes or doing other educational requirements, because that would look more like a job than an internship. So next factor is factor 5. So this is the extent to which the internship's duration is limited to the period in which the internship provides the intern with beneficial learning. So interns have, under this factor, tried to argue that the time they spent in the internship, it was too long in relation to the learning opportunities. They say, well, I learned what I needed to learn, but then they wanted me to keep working. But the courts have not taken that strict of a view of it to this point. They say it's more of a qualitative versus a quantitative approach. As one court put it, learning a practical skill may entail practice. So having someone do the same task over and over doesn't necessarily mean that you're putting too much burden on them, but it may just be that you're trying to give the intern a more real-world experience where they can really master something. So that's obviously going to be a very fact-specific, case-by-case question in these types of claims. Also looking at whether there's a finite time period for the internship. Most internships, like we talked about for the last factor, are going to be for a semester, for a summer, and those are all good showings that it was for a specific time period and it was intended for them to master certain skills during that time period, as opposed to being an open-ended program where someone can be an intern forever and never have the opportunity to go be an employee somewhere. So the next factor, factor 6, the extent to which the intern's work complements rather than displaces the work of paid employees while providing significant educational benefits to the intern. And this factor is a little more like the main consideration that was in the prior test. The prior test almost indicated that if an employer received any benefit from an intern, that it was less likely to be a true internship program. And obviously that was a hard standard to meet, because why would any employer have interns if it wasn't going to receive any benefit from them? Otherwise, you wouldn't want them around. So this test recognizes that, well, of course, an employer is going to receive some benefit from these individuals. Otherwise, they wouldn't have them on their premises. But it should be a complement rather than displacing the need to have paid workers. So it's really important to make sure that your interns would be getting a lot of oversight, a lot of involvement by your regular employees, so that it doesn't look like they're taking the place of an employee, but they are just potentially helping and learning from the existing employees. And your interns should not be the ones that would be responsible for the ultimate outcome of the work. It should still be that your full-time employees are the ones who bear the responsibility for the work, but they're checking or confirming things that the interns may have done. Okay, and the last factor, factor 7, is the extent to which the intern and the employer understand that the internship is conducted without entitlement to a paid job at the conclusion of the internship. So basically, and if you're giving the intern the impression that it's an entitlement to a paid job, it kind of looks like they're just a trial employee and not an intern. Internships are really, in the court's minds and in the Department of Labor's minds, are really supposed to be a training tool to give students or individuals the skills that they can go use at any number of employers, rather than just learning how to work for the specific employer where they're doing the internship program. So you're going to want to give them that broad base of skill that they can take elsewhere, and not make it look like you're just trying them on for size. So this next slide has some tips for what you might want to include in an agreement that you would have your intern sign. And it doesn't need to be something very long. You can very easily have a one-page agreement that sets out kind of the relevant details of the internship program, obviously stating that they're not an employee, and obviously you still want to be meeting all of the factors, or at least thinking about all the factors we discussed. The nice thing about the 7-factor test is the courts are not saying you have to meet every single factor. They're going to look at them, they're going to weigh them against each other, and they're going to kind of come up with an overall conclusion based on reviewing those factors. But obviously you want your agreement to say that they're not an employee, there's no expectation of compensation, that it is unpaid. It sets a definite duration of the internship, ideally, for a semester or a summer or a couple semesters. Say that they are not entitled to a job at the conclusion of the internship. It's not a practice run. And if it's connected to an academic program, setting out the circumstances of connecting it to the program and what's involved in that. Is there course credit? Is there an evaluation program? Will you be reporting back to the school? Is the intern required to submit certain reports as part of the academic program? So just strengthening all of the factors that we just discussed, and you can address a lot of those in this signed agreement. And then it's important to make sure that whatever's in the agreement is actually how the internship program is conducted going forward, of course. Okay, so this next slide has some more general tips on also avoiding the employee-employer relationship with your interns. Obviously, providing an educational experience. The internship should be primarily, for the benefit of the intern. They're there to learn, and giving them the training and support and guidance that they need is obviously key. Avoiding grunt work, rather than having your interns do the work that no one else really wants to do, shredding, filing, those sorts of things. They should be in there doing the things that will allow them to get a job later in that field. So if you can have a more formal training program, that's obviously very helpful. Where, I've myself been in interns where we have weekly meetings with the other interns. We have talks by people in different areas of the company, explaining what they do and what's been important to them in their career. And so all of those things are going to be helpful in showing that it's really a training, a learning experience. Again, no compensation or suggestion that there's an employment relationship, and limiting the duration.
Amy, I have a question.
Yes.
Is it okay to provide like a living stipend to interns, or would that be considered compensation?
So the question was, is it okay to provide a living stipend? And I would probably advise against that in most situations, although, obviously it would depend on the circumstances. The provision regarding volunteers and when compensation is allowed for volunteers, it's basically expense reimbursement, and they specifically reference transportation and meals. But I would say generally a living stipend, that's not an expense that's necessarily tied to the internship. Obviously that person would have to be paying for an apartment or living expenses no matter what they were doing. And so it's not something, it's sort of incidental to the internship relationship. So I would definitely use caution in providing any sort of stipend that's not directly based on submission of expenses like a meal receipt or gas receipts and things of that nature.
So you can reimburse them for mileage. Would that be okay if they're driving as part of their internship?
I think generally, yes. Mm-hmm.
Thank you.
Mm-hmm. So I have two examples here we can talk about, and they're kind of based on some cases. So example number one, and to try to illustrate these principles for you. So example number one is an internship for a magazine published by a nonprofit where journalism students take notes at staff meetings and publish articles on the magazine's website. Their work requires heavy editing, and they receive class credit as well as samples for their portfolios. So in this particular case, the interns were arguing that things like taking notes in meetings was menial work. They also argued that the magazine was benefiting by being able to sell ads against the work that they published on the website. And of course, they were contributing content, which obviously was also helpful to the magazine. But the court ultimately found that this was an internship relationship because the interns were not held to the same standards or expectations as full-time employees. They did write articles for the magazine, but they took much longer to do it. They were subject to a lot more feedback and revisions. And they weren't required to publish a certain number of articles per year. It was a very different standard than what would be applied to full-time employees. And it was very clear that it was meant to be a training experience. And ultimately, the interns were benefiting by getting to have a sample that they could put in their portfolio to show to a future employer. As far as taking notes at staff meetings, yes, I guess taking notes, could be considered menial work if that's all that an intern is doing. But the fact that they're getting to attend staff meetings and sort of participate in that process and observe that process, that actually is valuable to an intern. And so the court kind of recognized, even though the specific task may not be the most glamorous, the interns were doing a task that would be part of the professional environment and was giving them a learning experience. So the second example, I think, illustrates the problem that still is going to be had for people who want to have internship programs for people who are not part of an educational program. And I know that that's the case for some nonprofits, and I've worked with some of them on those issues where you have more vocational training to try to prepare people to enter the workforce, and it isn't part of an educational program. So this example, formerly homeless participants are given $40 a week to intern after signing a letter of agreement that they are not employees. Interns receive some training, counseling, and progress reports, but do not receive significant supervision on low-level tasks. Their work allows the nonprofit to offer services at a below-market rate. So some of the factors that we would kind of look at here in this fact pattern, you don't have an educational program, so already the new test is not as helpful to this type of scenario because the test is very heavily based on kind of the educational experience and the understanding that internships are kind of part and parcel with that. Here you have a stipend, and there's no indication of what this $40 is kind of supposed to represent and whether it really is a reimbursement of actual expenses. It's not clear that there's a fixed length of the internship, that it's a defined period and is meant to provide them the training that they can then use at another employer. And it's unclear whether the actual training provided, it says they do low-level tasks, is really preparing them to work somewhere else. It really may just be that they are only learning how to do this one job, as opposed to receiving a more broad-based training that would help them to go get a job elsewhere. A lot of times the courts are kind of looking at whether it looks like the employer is taking advantage of the intern, and they're going to kind of come down on, does it look like the employer's getting a lot more out of it than the intern is? So this case, there was a case against Gawker Media. The court said, if the economic reality is that the intern is providing free labor without receiving significant educational or vocational benefits in return, the outward trappings of an internship will not prevent the court from determining an intern is an employee. So in that case, they did agree that the program was an internship, but they're recognizing that they need to an employer would need to show that there's significant educational or vocational benefits, not just an attempt to get free labor out of people. Okay, so really the bottom line, potential liability. So it is important for me to note that the DOL has said that unpaid internships for nonprofit charitable organizations where the intern volunteers without expectation of compensation are generally permissible. So the DOL does recognize that this is a standard arrangement in the nonprofit world, and that a lot of these internship programs are going to be just fine under this test. However, they've provided no further guidance for nonprofits. In addition to this, it's a footnote to the fact sheet on internships that says this generally permissible statement. So outside of this footnote, we have no real other guidance on how if this test may be applied differently to nonprofits. So you really should assume that this test would apply to your internship programs and try to look at your program and how it might meet these factors. Nonprofits have been sued in the past by former employees, so they employees that were classified, as volunteers. So I have, there's no indication that you wouldn't have possibility of being subjected to suit from former internship participants. So as always, the factors are going to be a little malleable, and it's going to be very fact dependent on your particular case. But these are the considerations that we would advise you to look at when you are considering an internship program or looking at an existing internship program. So do we have any more questions?
We do have some questions. This might be outside the scope of today's conversation, but do you have any advice on if an intern is assigned to HR? Do you have any advice on whether or not they should have access to confidential information?
Okay, so the question was, if an intern is assigned to HR, do I have any advice on whether they should be given access to confidential information? I think that's obviously going to be a sensitive situation for them, because you don't have that employment relationship with the person, that if they do breach the employer's confidence, you don't have the same type of remedies that you might have with an employee. I mean, you can let them go from the internship, but that's a little different than firing an employee. I just think an employee has obviously more incentive to take the proper care with those sorts of materials. So I do think you would want to be cautious in giving an intern access to sensitive materials that you wouldn't provide to other employees in other departments, just because of the nature of the relationship is a little different. And if they're if they're a student, they just may not have the proper training and how to handle those types of matters. But if you do have a scenario where you have an intern who is going to be dealing with sensitive matters or more trade secret type matters, I mean, you certainly should put the proper protocols in place for the intern about what's expected of them and what they need to keep confidential, and probably have an agreement in place explaining those obligations to them.
And if an organization compensates its interns and otherwise treats them as part-time employees, what are the legal risks to the organization?
So the question was, if an organization compensates interns and treats them as part-time employees, what are the legal risks? Well, if you're treating them as part-time employees, and that would be paying them minimum wage, and if they're not working more than 40 hours a week, you don't have to pay them overtime. And if they do work over 40 hours a week, you would have to pay them overtime. But if you are paying them minimum wage, you're not having wage and hour consequences, but you would need to consider, if they are employees of yours, then you would be subject to the other laws relating to employees, such as the the discrimination laws and workers' comp and, all the various obligations that you have as an employer in relation to any other employee.
One more question. My organization doesn't currently have an intern program, but do you have any recommendations for creating a good supervisory schedule if we do create an intern program going forward? Like how to supervise the interns adequately under the factor test.
Oh, okay. So the question was, if when creating a new internship program, advice for how to supervise interns and creating a good protocol for that. I think it depends on the size of the organization, obviously, how formal that would be. At a minimum, the intern needs to have some sort of supervisor that is responsible for the internship experience of that particular individual, that gives them regular feedback and gives them assignments and just kind of is assigned to them to shepherd them through the internship experience. But large organizations, they have one person who is responsible for the internship program as a whole and puts together, a more formal program. But a formal program is not necessary, but at the minimum, you would need to have someone with explicit responsibility for the intern and making sure that there's some protocols in place as to how the intern is evaluated and given assignments, and that it's different than how normal regular employees are treated.
We have one final question. Can an organization have an internship program that is not connected to an academic program, so that they're not receiving, academic credit for it?
Okay. The question was, can an organization have an internship program that's not connected to an academic program? And not all interns offer academic credit, and that's something that is not required for a bona fide internship program. It does get trickier if it's really not connected to an academic program in any way. One example in the case law was a journalism internship. Some of the students were currently in school and working for the organization. Others had recently graduated and they were doing an internship, and the court was fine with all of that because it was clearly connected to the students' major, their coursework, and in furtherance of their professional goals. If it's adults who, like the example of the formerly homeless participants who are not in any way connected to an academic program, I think that's a harder program to devise under these factors because they are so heavily focused on the academic nature, but they also do recognize vocational training, and so to the extent that the program is offering very specific vocational training that the interns could use elsewhere and is not specific to the employer and the work that the employer does, I think that's going to be the type of internship program that a court would consider, viable. But yeah, like I said, it's a little unclear under the new factors when it's a non-academic program how that's going to be viewed, because that's sort of how the cases have evolved. It's been younger students and recent grads who have been bringing these cases, so that's sort of the guidance that we have at the moment.
That's all. Thank you.
All right. Thank you so much for being with us today.